Yesterday, I had brought first part of the outstanding features of our Indian Constitution. Today, I am discussing about the part two of the outstanding features of our Indian Constitution. Part 2 starts from here. In various articles, therefore, the Constitution lays down certain basic principles and empowers Parliament to supplement these principles by legislation. Thus, first, as to citizenship, Article 5 to 8 only lay down the conditions for acquisition of citizenship at the commencement of the Constitution, and Article 11 vests plenary powers in Parliament to legislate on this subject. In pursuance of this power, Parliament has enacted the Citizenship Act 1955 so that in order to have a full view of the law of citizenships in India, a study of the Constitution had to be supplemented by that of the Citizenship Act. Similarly, while laying down certain fundamental safeguards against the preventive detention, Article 22, subsection 7 empowers Parliament to legislate on some subsidiary matters relating to the subject. The laws made under this power have therefore been read along with the provisions of Article 22. Article 22. Again, while beginning untouchability, Article 17 provides that it shall be an offence punishable in accordance with law. And in exercise of this power, Parliament has enacted a Protection of Civil Rights Act 1955, which must be referred to and as supplementing the constitutional prohibition against untouchability. While the Constitution lays down the basic provision relating to the election of the President and Vice President, Article 71(3) empowers Parliament to supplement these constitutional provisions by legislation, and by virtue of this power, Parliament has enacted the Presidential and Vice Presidential Elections Act 1952. The obvious advantage of this scheme is that the law made by the Parliament may be modified according to the exigencies for the time being without having to resort to a constitutional amendment. There are, again, a number of articles in the Constitution which are of a tentative or transitional nature, and they are to remain in force only so long as Parliament does not legislate on the subject. Exemption of union property from state taxation, suability of the state. The Constitution thus ensures adaptability by prescribing a variety of modes in which its original text may be changed or supplemented, a fact which has evoked approbation from Professor Weir. This variety in the amending process is wise but is rarely found. This wisdom has been manifested in the ease with which Sikkim, a protectorate since British days, could be brought under the Constitution, first as an associate state and then a full-fledged state of the Union, 36th Amendment Act 1975. Fifth, the combination of the reconciliation of a written constitution with parliamentary sovereignty. This combination of the theory of fundamental law, which underlies the written constitution of the United States, with the theory of parliamentary sovereignty, which underlies the unwritten constitution of England, in the result of the liberal philosophy of the framers of the Indian Constitution, which has been so nicely expressed by Pandit Nehru. While we want this constitution to be as solid and permanent as we can make it, there is no permanence in constitutions. There should be a certain flexibility. If you make anything rigid and permanent, you stop the nation's growth and growth of a living, vital, organic people. In any event, we could not make this constitution as rigid that that it cannot be adapted to changing conditions. When the world is in turmoil and we are passing through a very swift period of transition, what we may do today may not be the wholly capable of tomorrow. The flexibility of our Constitution is illustrated by the fact that during the first 50 years of its working, it has been amended 83 times. Vital changes have thus been effected by the 5th, 4th, 24th, 25th, 39th, 42nd, 44th, so 73rd and 74th amendments to the Constitution, including amendments to the fundamental rights power of the Supreme Court and High Courts. Dr. Jennings characterized our Constitution as rigid for two reasons: that the process of amendment was complicated and difficult, that matters which should have been left to ordinary legislation having been incorporated into the Constitution, no change in these matters is possible without undergoing the process of amendment. We have seen that the working of the Constitution during 5 decades have not justified the apprehension that the process of amendment is very difficult. But the other part of his reasoning is obviously sound. In fact, his comments on this point have proved to be prophetic. He cited Article 224 as an illustration of a provision which had been unnecessarily embodied in the Constitution. An example taken at random is Article 224, which empowers a retired judge to sit in a high court. Is that a provision of such constitutional importance that it needs to be constitutionally protected and be incapable of amendment except with the approval of 2/3 of the member of each house sitting and voting in the Union Parliament? As Table 4 will show, it has required an amendment of the Constitution, namely the Seventh Amendment of 1956, to amend this article to provide for the appointment of additional judges instead of recalling retired judges. Similar amendments have been required once to provide that a judge of the High Court who is transferred to another High Court shall not be entitled to compensation, Article 222. And again, to provide for compensation, it is needless to multiply such instances since they are numerous. The greatest evidence of flexibility, however, has been offered by the amendments since 1976. The 42nd Amendment Act 1976, after the Constitution had worked for over a quarter of a century, introduced vital changes and upset the balance between the different organs of the state. Of course, behind this flexibility lies the assumption that the party in power wields more than a 2/3 majority in both houses of parliament. It is very remarkable that though the framers of the Constitution attempted to make an exhaustive code of organic law, room has been left for the growth of conventions to supplement the Constitution in matters where it is silent. Thus, while the Constitution embodied the doctrine of cabinet responsibility in Article 75, it was not possible to codify the numerous conventions which answer the problem as they may arise in England from time to time in the working of the cabinet system. Take, for instance, the question whether the ministry should resign whenever there is an adverse vote against it in the House of the People, or whether it is at liberty to regard an accidental defeat on a particular measure as a snap vote. Again, the Constitution cannot possibly give any indication as to which issue should be regarded as a vital issue by a ministry, so that on a defeat on such an issue, the ministry should be morally bound to resign. Similarly, in what circumstances a ministry would be justified in advising the President to dissolve parliament instead of resigning upon an adverse vote can only be established by convention. Sir, Ivor Jennings is therefore justified in observing that the machinery of government is essentially British and the whole collection of British constitutional conventions has apparently been incorporated as conventions. While the directive principles are not enforceable in courts, the fundamental rights included in Part 3 are so enforceable at the instance of any person whose fundamental right has been infringed by an action of the state, executive or legislative, and the remedies for enforcing these rights, namely the writ of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, are also guaranteed by the Constitution. Any law or executive order which offends against a fundamental right is liable to be declared void by the Supreme Court or the High Court. It is through a misapprehension of these provisions that the Indian Constitution has been described by some critics as a lawyer's paradise. According to the Sir Ivor Jennings, this is due to the fact that the Constituent Assembly was dominated by the lawyer politicians. It is they who thought of codifying the individual rights and prerogative writs, though none in England even ever cherished such an idea, in the words of Sir Ivor. Though no English lawyer would have thought of putting the prerogative writs into a constitution, the Constituent Assembly did so. These various factors have given India a most complicated constitution. Those of us who claim to be constitutional lawyers can look with equanimity on the exaltation of our profession, but constitutions are intended to enable the process of government to work smoothly and not to provide fees for constitutional lawyers. The more numerous the briefs, the more difficult the process of government becomes. India has perhaps placed too much faith in us. With due respect to the great constitutional expert, these observations disclose a failure to appreciate the very foundation of the Indian Constitution. Sir Ivor omits to point out that the father of the Indian Constitution preferred the American doctrine of limited government to the English doctrine of parliamentary sovereignty. In England, the birth of modern democracy was due to a protest against the absolutism of an autocratic executive, and the English people discovered in parliamentary sovereignty an adequate solution of the problem that faced them. The English political system is founded on the unlimited faith of the people in the good sense of their elected representatives, though of late detractions from its omnipotent authority have taken place because the ancient institution at Westminster has grown incapable of managing myriads of modern problems with the same ease as in Victorian age. Nonetheless, never has nobody in England thought of placing limitations on the authority of Parliament so that it might properly behave. The founding fathers of the American Constitution, on the other hand, had the painful experience that even a representative body might be tyrannical, particularly when they were concerned with a colonial empire. Thus it is that the Declaration of Independence recounts the attempts of British legislature to extend an unwarrantable jurisdiction over us, and how the British people had been deaf of the voice of justice. At heavy cost had the colonists learnt about the frailty and weakness of human nature when the same Parliament which had forced Charles I to sign the Petition of Right 1628 to acknowledge that no tax could be levied without the consent of Parliament, did in 1975, and the years that followed insist on taxing the colonies regardless of their right of representation and attempt to enforce such undemocratic laws through military rule. Hence, while the English people in their fight for freedom against autocracy stopped with the establishment of the supremacy of the law, the Parliament as the sole source of that law, Americans had to go further and assert that there is to be a law superior to the legislature itself, and that it was the restraints of this paramount written law and could only save them from the fears of absolutism and autocracy, which are ingrained in human nature itself, as will be more fully explained in the chapter on fundamental rights. The Indian experience of the application of the British rule of law in India was not altogether happy, and there was a strong feeling that it was not administered with even hands by the foreign rulers in India as in their own land. The sons of liberty in India had known to what use the flowers of the English democratic system, which the sovereignty of Parliament and the rule of law could be put in trampling down the rights of a man under an imperial rule. So in 1928, long before the dawn of independence in India, the Motilal Nehru committee asserted that our first care could be to have a fundamental rights guaranteed in a manner which will not permit their withdrawal under any circumstances. Now, judicial review is a necessary concomitant of fundamental rights, for it is meaningless to enshrine individual rights in the written constitution as fundamental rights if they are not enforceable in courts of law against any organ of the state, legislative or executive. Once this choice is made, one cannot help to be sorry for the litigation that ensures whatever apprehensions might have been entertained in some quarters in India at the time of the making of the Indian Constitution. There is hardly anybody in India today who is aggrieved because the Supreme Court each year invalidates a dozen of statutes and like number of administrative acts on the ground of violation of the fundamental rights. At the same time, it must be pointed out that since the inauguration of the Constitution, various provisions have been inserted in the Constitution by amendments which have taken out considerable areas from the pale of judicial review, as for example by inserting Article 31A to 31C, and by 1995 as many as 284 acts, central and state, have been shielded from judicial review on the ground of contravention of the fundamental rights by enumerating them under the 9th schedule, which relates to Article 31B. An independent judiciary having the power of judicial review is another prominent feature of our Constitution. On the other hand, we have avoided the other extreme, namely that which of judicial supremacy, which may be a logical outcome of an overemphasis on judicial review, as the American experience demonstrates. Judicial power of the state exercisable by the courts under the Constitution as sentinels of rule of law as a basic feature of the Constitution. This is all about today's part of outstanding features of our Constitution. Thanks, regards.